Hello, this is Matt on the Moon Lambeau channel. More legal happenings today in the SEC v. Ripple case, and I'll tell you right at the outset of the video, I have a number of comments and perspectives from attorney Jeremy Hogan, and he says, and I quote, "I think the SEC will win this motion," end quote. And I'll share with you exactly why he's saying that. And he seems to say it with a little bit of regret. Well, we don't want the SEC to win anything. He's just being intellectually honest, of course, here. But here's the post from attorney James K. Filan of the XRP community sharing the latest Ripple filing, and he wrote, Ripple has filed a letter in further support of its April 22nd, 2024 motion to strike new expert materials, and in reply to the SEC's April 29th, 2024 opposition to that motion to strike. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, and I think that you today did a pretty good synopsis of this. Here's the headline: Ripple ramps up effort to strike SEC's expert materials. So let's run through this real quick, and then the rest of the video is going to be everything from attorney Jeremy Hogan. Anyway, reads as follows. San Francisco-based company Ripple has filed a new letter to bolster its motion to strike the U.S. Securities and Exchange Commission's expert materials. As reported by you today, Ripple moved to strike the expert materials from Andrea Fox, an assistant chief accountant in the regulator's Division of Enforcement. Its key argument against the SEC hinged on the untimely disclosure. The defendant said that the regulator was supposed to disclose its expert witness before the final stage of the discovery. Ripple took issue with the fact that Fox was not disclosed as an expert witness. Instead, she was described as a summary witness by the SEC. And so you may recall, because I made a video where I was covering this in greater detail, but just want to mention this to set the table for anybody that may have missed this. Ripple's argument is just that, as described by you today here. And so look, I'm not an attorney. I just play one on YouTube. But so we'll see what ultimately the judge concludes here. But if it's indeed the case that this is what the SEC is doing, basically the intent would be to have Andrea Fox, one of their accountants at the SEC, provide more information than would be potentially necessary for the particular role that you'd expect from somebody who's just a summary witness. So basically, the argument is, in a nutshell, part of it anyway, that the SEC is trying to sneak in more information that actually was supposed to be disclosed during the discovery process years ago. That's part of the argument that Ripple's making. So it does materially matter which type of witness Andrea Fox is. So that's what they're arguing here. So Ripple's saying, hey, the SEC is doing something sneaky and underhanded here, and the SEC is arguing, no, she's just an accountant reporting the facts. That's what they're saying here. Anyway, piece continues. In its most recent filing, Ripple says that the SEC has no good explanation as to why Fox's declaration touts her as an accountant if she is not testifying as an expert. And I'm going to show you exactly what was written by Ripple, so we'll come back to that exact point here. But anyway, Ripple asserts that Fox did much more than simply copying, pasting, and adding numbers. Furthermore, it says that the SEC's cases do not support the agency's characterization of a summary witness. Quote, and this is from Ripple, even if Fox were a summary witness rather than an expert, the parties' agreement and the court's scheduling order required the SEC to disclose her before the close of discovery, end quote. And so here is what attorney Jeremy Hogan had to say. He reposted the most recent filing from attorney Filan, and attorney Hogan wrote the following. The hardest thing to do on crypto Twitter is say that you think the SEC will win a motion, but here goes. I think the SEC will win this motion. And even if the court finds the witness is an expert, I think instead of striking the witness, it will just allow Ripple to depose her, etc., like it did before. Now, excuse me while I go pray I'm wrong, which is not often, smiley face. That's true. He's been way more right than wrong. He's got quite the track record of calling stuff in the SEC v. Ripple case, unquestionably. So what he's saying here is, even if Ripple gets their way and the judge agrees, yeah, that's right, this is an expert witness, Andrea Fox will still be participating. That's the guess, even if Ripple gets its way. Rather than striking the witness, then there would just Ripple get to depose her, and then basically it's what they would have gotten to do if it had been done in the proper timely manner. If this had been disclosed back during discovery, it'll just happen after the fact now, which I don't think is what Ripple is hoping for. Here's a post from XRP community member Sherry, and based on the stuff that I've seen her write over the years, I'm guessing she's an attorney, but I don't technically know for sure. But she wrote the following. This is in response to Attorney Filan. I am hesitant about this letter in support of the motion to strike. Ripple uses a fair amount of quotes from Fox's declaration, and without viewing the exhibits, I cannot determine how much, if any, is taken out of context. Then XRP community member who goes by the name Tipsy Tiger responded to that and wrote, in response to section 1C, which I'll show you in just a second here, he re-references that in his post, and he says, surely 1C shows she fits the profile of an expert witness. The SEC could have chosen an intern from the post room, but they didn't, and we all know why. I also think, too, the second paragraph doesn't bode well for the SEC, reasonably confident the judge remarks on that alone. Now, I'll show you 1C in just a second here, but I want to note that Attorney Hogan responded to that and said, striking a witness is a fairly extreme thing to do, and I wouldn't do it here. It also opens the judge up to being overturned later. And so where's the... here it is. Let me get to 1C. So this is what was filed today from Ripple's attorneys. This part right here, which I can't highlight because it's screen grab. So anyway, it's this right here. It reads as follows. The SEC also has no good explanation for why, if Fox is not testifying as an expert, her declaration touts her qualifications as an accountant. Instead, the agency asserts that while Fox did not utilize her specialized knowledge in any way, her declaration includes her qualifications to give the court some comfort that her math is correct. It is not plausible that Fox gave details about her 14 years at PricewaterhouseCoopers, including forensic services advisory work, and her credentials as a certified public accountant and certified fraud examiner, merely to show that she could do basic arithmetic. Yeah, and so that does seem like overkill. That's a pretty good argument on Ripple's behalf here, but still it doesn't change the calculus in Attorney Hogan's opinion here. It's just not something that would typically happen. There was also another post from Sherry writing to Attorney Hogan this time, and she wrote, I was just telling Mark that making Fox an expert witness might make things more complicated. If it is discovered that she is a summary witness, then no harm. By allowing the deposition, she protects the record on appeal. This way, neither party can claim prejudice. And so it goes back to what Attorney Hogan was thinking of on his own. And he actually responded. He said, I agree, and if I had to bet, I think that's what she'll do. So, if she's found to be an expert witness, and then there's a deposition, if there's an appeal, then that's actually going to be counterproductive for Ripple. I think that's the argument there anyway. Here's a post from somebody named Jack writing to Attorney Hogan, said, are we going to win, Jeremy? And Attorney Hogan wrote in response, if the judge rules an amount that Ripple can pay, it wins. Yeah, and so that's certainly true, and I suppose that's what's most probable at this point in time. Now, either way, XRP has legal clarity. Then there was this post from somebody named Low Key Money wrote to Attorney Hogan and said, so they won't win, question mark? And Attorney Hogan said, just this one motion, which was a bit of a long shot anyways. It doesn't change anything, even if they lose this motion. And so that's the good news. Even if Ripple doesn't get their way on this, big picture for all of us XRP holders, it's good. And even for Ripple, they're going to turn out fine in all likelihood. It's a virtual certainty at this point, as far as I'm concerned. Somebody named hodlerme.x wrote to Attorney Hogan and said, once summary judgment is done and the SEC settles, no more appeal can be done, right? And Attorney Hogan did respond and said, once the judge rules, either party can, and probably will, appeal. Or they can settle as well, and then there would be no appeals. Now, folks, that's, I wouldn't mind. On the remedies portion, because look, the judge already ruled. The judge has made the rulings. So on the remedies portion, if we can get a settlement there, that would be absolutely fantastic. That would probably be the ideal situation, just to get this all buttoned up and we don't have to worry about years of appeals. And then somebody named Gardy wrote to, or tagged Attorney Hogan here and said, Attorney Jeremy Hogan, is your best estimate for July/August ruling before appeals taking case into 2025? And then he responded with exactly, which is how he says the word exactly. And so that's the timeline. He's thinking, unless there's some sort of settlement, you're looking at a decision here, July and August, and that would be, in theory, the end of it, except for if there's an appeal, which seems like there's a high probability of that, so is what it is. But that is the latest. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.